Excuse me? Are you talking to me? I'm taking my crops here. Why? Is there any problem with that?
Stop it! You have no right to this land and also the crops.
What are you talking about? Are you kidding me? Who are you to tell me that I have no right to this land? This is my land as I have cultivated it.
I am the collector by the order of the government in the exercise of the power given to him by Act 12 of 1839, existing him to eject person in the occupation of land then under a grant title from the ruler. I am here for the reason to eject you and your family from this land because you failed to take up proper title from this land.
No, I have right to this land. It was a forest before and I cultivated this land when I cleared it in 1829. I also paid 1/10 of the produce to the ruler.
You are not a cultivator or resident tenant holding by prescription. This land had been assessed by the ruler and was also therein called upon by us to take up proper title for this land in default. Hence, you would be ejected.
I can prove that this land belongs to my family. I will sue you for trespassing on my land. So, see you in court.
Alhamdulillah. Thank you everyone. After much deliberation, I have come to my judgment. Please, Mr. Sarip, the plaintiff and defendant, please take a seat along with their counsels. Before I come to my judgment, first and foremost, I have to say, it is well known that by all Malay law or custom in Malacca, while the sovereign was the owner of the soil, every man had nevertheless the right to clear and occupy all the forest and wasteland, subject to payment to the sovereign itself of 1/10 of the produce of the land taken. The trees which he planted, the houses he built, and the remaining 9/10 of the produce were his property. He could sell them, mortgage them, or give it to his children. If he abandoned the paddy lands or fruit trees for 3 years, or gambir or pepper plantations for a year, his right ceased and all of it will revert back to the sovereign. If, however, without deserting the land, he left it uncultivated longer than was usual or necessary, he will then be liable to ejectment. It was contended by the defendant that such custom was unreasonable and therefore invalid. But if such an objection could now be raised, I shall presently show without any hesitation that the custom was not only reasonable, but very well suited to a country like this, where the population is very thin and it is uncleared land is superabundant and has no value. It must be for the advantage of the state itself to attract settlers to the land, which are worthless as forest and swamp, and thus to increase at once the population and wealth of such a country. This is similar amongst other nations in this area, including those in Sumatra and in Java. The Portuguese and later the Dutch, when they occupied Malacca, left the Malay custom in force. That was in force when this settlement was ceded to the crown appears to be beyond dispute, and that cession has left the law unaltered is equally plain on general principles. Further, the custom has only been recognized by the government down to the present time. Tenths are collected, both in kind and in money, from the holders of the land acquired under the custom. From 1838 to 1853, commutation of tenths into money payments were frequently made by deeds between East India Company and its tenants. The Malacca Land Act of 1961 that the defendant used plainly refers to and recognizes the same customary tenure when it declares that all cultivators and resident tenants of lands who hold their title by prescription are and shall be subject to payment of 1/10 of the produce thereof to the government, either in kind or in money fixed in commutation. Therefore, I would like to help that it is rather plain and clear that the plaintiff in our case was not liable to ejectment by the collector for declining to take out a proper title for the land in his occupation under the Act of 1839. It was forest and uncultivated land when he cleared it in 1829, and he paid thanks to the government from that time until 1853, when he was appointed Penghulu. This appointment he held until 1868, and during his tenure of it, he was as usual exempted from payment. However, when he was deprived of the appointment of Penghulu in 1869, he continued paying tenths again in 1869. He is therefore plainly one of the customary tenants protected by the 12th section of the Act of 1839. You may now leave the court.
Wait. What are you guys doing in my land? Don't you see this notice?
Waalaikumsalam. Who says this is your land? This is state land. No one ever registered this land under Land Regulations 1889. So we have the right to planting and logging here.
Actually, this is a royal gift from Sultan of Pahang. And you know Sultan Muazzam Shah, he actually my grandfather, And he gave this land to my mother Tengkulong. And my mother gave this land to me under Badie'ah under Muslim law. And you know what? I am the beneficial owner and the legal owner of this land. So I have the rights over this land. And you, what are you waiting for? Get lost.
Excuse me, you never took possession of this land for all this time and suddenly you want to claim that this land is yours.
My, this is so unfair. You know what? Let's go to the court. Let's see who has the right to this land. See you in the court.
We will begin our trial for the case of Tengku Haji Jaafar bin Almarhum Ibnu Tengku Muda against Government of Pahang.
May it please Your Honour. My name is Raja Azhar, and together with my co-counsel Abdul Razak Ahmad, appear as the counsel representing the appellants. If it pleases Your Honour, I will begin my first submission. Your Honour, the late Sultan gave the land to the appellant's mother, Tengku Long. It is unfair to say that the land does not belong to the first appellant because the first appellant received by way of gift inter vivos from Tengku Long the whole of her undivided share in the said land. Thus, the land was a gift made under Muslim law and had been duly perfected by the first appellant so that he became the legal and beneficial owner of the one of the said land. Thus, Your Honour, based on these facts, both appellants together are accordingly the beneficial owner, one of half of the said land. However, the respondent had knowingly and unlawfully exercised dominion over the land and had alienated by way of license or lease various portions thereof to various persons and bodies for the purpose of the logging and planting. Hence, it caused wrongful loss to the appellants by depletion of the timber therein and by keeping to itself the income from such alienation. Secondly, the respondent also had unlawfully kept out the appellants from the said land in spite of several notices informing the respondent that the said land had been subject to of a royal gift in the appellant's favour. The respondents had ignored these notices and had continued to exercise unlawful dominion over the land, thus preventing them from enjoying it, thereby causing loss and damage to them. Therefore, Your Honour, I hereby, as the counsel for the appellants, plead for declaration that the original gift is valid and subsisting, restitution to the appellants of all those portions of the said land which the respondent had wrongfully alienated, and for damages and costs.
May it please this Honourable Court, I am Datuk Wan Muhammad bin Wan Muda, the State Legal Advisor of Pahang. I appear as counsel for the respondent. Your Honour, I submitted that the respondent lawfully exercised dominion over the said land and have the right to alienate it to various persons and bodies. Based on what had been said by the counsel of appellant, I agreed that we practice Islamic rule, and this case is pertaining to the gift or hibah. I submitted that in order for the gift to be valid, by referring to Kitab Minhaj al-Talibin, a gift will only be valid when the donee takes possession of the gift land at the time the gift is made. This principle is applied in the Privy Council cases of Muhammad Abdul Ghani and Nader and Fakir Jahan Begum and others, and also in the case of Amjad Khan and Ashraf Khan. In these two cases, their lordships accepted the view of Syed Amir Ali that to constitute a valid gift, there must be three constituent elements, which are firstly, a manifestation of the wish of the donor to give, secondly, the acceptance of the donee, either implied or expressly, and thirdly, the taking possession of the subject matter of the gift by the donee, either actually or constructively. Thus, it can be seen that the appellant does not fulfill the third element in the sense that there is nothing to show in the statement of claim that the donees had ever taken possession of the gift land at all, either actually or constructively. Hence, the gift failed even though the other two elements are fulfilled by looking at the royal document mentioned by the appellants. Your Honour, we also submitted that the gift land was never brought into the system of the 1889 land regulation at all. The regulations enacted that all lands in the state were divided into the four classes. In our current case, the related classes of land would be land available for agricultural purposes and land in occupation of native under Malay tenure. Under the regulations, all holders of concessions of land for agricultural purposes, which were granted by the Sultan, had first to be recognized by the state government and required to be registered. If it failed to register, the concession are void. As regards to the lands occupied by native under Malay tenure, such lands also need to be registered. If it is failed to register, the right of the occupiers in respect of such lands liable to forfeiture. Thus, Your Honour, I submitted that the gift land, whether it was treated as a concession or as a native occupied land under Malay tenure, had never been registered, thus remained as state land.
Objection, Your Honour. There was evidence that the land actually had been given to the appellants without any cancellation from the Sultan. This is the diary that the appellant had given. This diary, dated January 4, 1901, was kept by the late Sultan Ahmad Muazzam Shah concerning the gift land. According to this diary, the late Sultan wrote a letter on October 12, 1900 to British Resident Hugh Clifford, in which he maintained that although the late Sultan agreed to request by the British resident to cancel all concession, he, however, did not consent to the cancellation of this gift to his children and to other absolute grants. Thus, the land that was given by Sultan to Tengku Long and Tengku Dalam is a valid gift. Hence, the respondent should not interfere with the land as it originally belongs to the appellants.
Objection, Your Honour. I object to the admissibility of the diary on the ground of lack of authenticity and of the hearsay contents of the letter written by the late Sultan on October 12, 1900, which the diary purported to have stated. I submitted that the diary cannot prove the appellant's title to the gift land. The diary seems to indicate that the Pahang state government did not recognize the title of the gift land, and that is why the late Sultan pleaded with the British resident to accord recognition thereto so that it could be registered under the General Land Regulations 1889. Thus, this diary is therefore cannot be used as an argument by the appellants.
Objection allowed for the state of Pahang. Now that I have heard from both parties, now I'll give my judgment. But before I give my judgment, let us go back to the history of Pahang, whereby during that time the late Sultan Muazzam Shah was the undisputed ruler of Pahang after the demise of his father Bendahara Tun Ali in 1857. And he was also known as not someone who was keen to the influence of British. But after that, in 1887, he signed an Anglo-Pahang treaty with British because he was persuaded by Sultan of Johor. And bear in mind that the gift that he made to his daughters at that time was before the Anglo-Pahang treaty was made. Soon after that, he then abdicated his throne to his son. After he abdicated his throne to his son, then the British also made a law which called as General Land Regulation, or also known as Pahang Land Regulation. So starting from that, British has been giving concession on behalf of the Sultan. From this, we can see that the land law applicable during this time was the Sharia law that was under the Shafi'i school, and that after the government land regulation in 1889 was applied, then the law of the general land regulation take place. So here, since the Muslim law apply, the issue here, as has been stated by the State Council, is whether the issue or the state land fulfill the requirement of the gift according to the Sharia law. So I agree with what has been stated by the council, that the requirement was not particularly fulfilled on the position, and it also made and result to uncertainty of the land being not the state land of the state gift. And we also need to take note that the Sultan do have the discretion of power to vested any land to anyone because he has the right as a ruler. So in this case, I decide that if it were treated as a concession, it was never recognized by the state government, nor it was registered. And if it were regarded as a native occupied land under the Malay tenure, it was also not registered as required by the regulations. So it is obvious, therefore, that the gift land was at all time a state land, and its ownership was never transferred to the donee. So that being the case, this land therefore remain a state land and continue to be so under successive land legislation. Appeal dismissed.
So, based on those two cases we see just now, the land law at that time consisting of a blending of Islamic law and Malay custom. According to the case of Sahrat vs. Mitchell and others, we will observe that the characteristic of Malay customary tenure is that the method of acquisition of land is by opening up and cultivating virgin jungle or wasteland, reflected to the principle of Ihya al-Mawad, which had been practiced since the time of Prophet sallallahu alaihi wasallam. Also, it is an obligation to pay 1/10 of the proceed to the ruler, conforms to the duty to pay ush, which literally meaning 1/10 in Islam. Besides that, the characteristic of Malay customary tenure is that the nature of ownership is not one of absolute ownership, but it is based on the proprietary rights, where the right of ownership extends not to the soil, but to the usufruct or the right to utilize the soil. In Islam, all things belongs to Allah subhanahu wa ta'ala absolutely. Apart from that, there is the need to maintain the land under continuous cultivation, conforms to the Islamic injunction against waste. If the land was neglected or abandoned for any substantial period of time without any reasonable cause, it would be forfeited by the ruler, and the owner would lose all his right in the land. However, adat perpatih, which is also known as adat nanim, differs from the land tenure described in the Malay Annals and Digest. The rule of succession prescribed by adat nanim and adat perpatih as land can be owned by women only. The woman may not travel, but the husband settled in his wife's village and not the wife in the husband. After Islam came to Malacca, the rules of Islamic law relating to the land tenure had regulated the affairs dealing with the land of the Malays. The practice of local custom of the people relating to land tenure continued to be practiced with the fusion of the principle of Islam land tenure without alteration. The customary tenure of adat Temenggung is that of early of Malay land tenure, where a cultivator of the land owns it subject to payment of 1/10 and continued cultivation. Adat Temenggung is a non-tribal adat, as such personal laws of the Malaysia in relation to the marriage, succession and similar matter is that of Sharia modified by adat. Sir Maxwell in the Malay Digest described Malay customary land tenure as follows. The Malay cultivator can transfer only the interest in the land which he himself possesses that interest. The matters related to the succession of land were decided in accordance with the Sharia as modified by the Malay custom.
In the case of Tengku Jaafar, we can see that the Malay customary tenure had infused and derived the principle of Islamic law of Shafi'i school, whereby in this case it was highlighted to constitute a valid gift under Islamic law, there must be three constituent elements, which are the first one is the manifestation of the wish of the donor to give, the second element is the acceptance of the donee towards the gift either by expressly or impliedly, and the last one is the taking possession of the state gift either actually or constructively. The existence of principle of Islamic law and adat can be found in many old Malay digests, for instance the Malacca Law 1523, the Pahang Law 1596, and also the Johor Law 1789. There are three dealings that have been practiced since a long time ago, which are pulang belanja, jual janji or also known as kadai, and sewa. Pulang belanja is a return of expenses, whereby if the owner wishes to sell his land, the price which he could expect from the purchaser would be the total sum of labour and expenses which he incurred in cultivating and developing the estate land. Jual janji, or also known as kadai, is a dealing between borrower who transferred his own land to the lender and upon full settlement of the loan is entitled to get back his land. It has been done in form of oral understanding as there is no actual documentation or registration. If failed to redeem, the deal is considered as jual putus or absolute sale. It can be practiced among non-Muslim and also Muslims. The last dealing is sewa, which also known as leasing. It is a dealing between a borrower who transferred his own land to the lender for a temporary period. The practice of Malay customary tenure nowadays can still be accepted as mentioned in Section 4, Subsection 2, Paragraph A of the National Land Code, where it stated that, except insofar as it is expressly provided to the contrary, nothing in this Act shall affect the provision of any law for the time being in force relating to customary tenure. This portrayed that the National Land Code does not override existing law on Malay customary tenure. For instance, the Malacca Customary Land under Part 8 of National Land Code Penang and Malacca Tiles Act 1963 can still be accepted and practiced in our country. And also the Negeri Sembilan Customary Tenure Enactment 1926 and the Part 3 of Small Estate Distribution Act 1955.